यहाँ पर उल्टा दिखेगा बट
हाँ आई नो, दिस नॉट ऑन, रिकॉर्डिंग इज नॉट ऑन।
कैमरा में भी यही पर रिकॉर्डिंग हो रहा है।
उस पे नहीं कर रहे एसडी कार्ड
इस
पे?
पे आ जाता है सर।
ओके,
अच्छा डन।
एक चलने दो, बहुत ज़्यादा हो रहा है। Okay friends, welcome to today's session. In fact, there has been a long gap since I met you people, and your exam is very fast approaching, isn't it? Exactly a month now. Today is 28th, so you have your exam on 28th of May. But don't let the pressure come on you. This is, I think the course is going to be over in a couple of sessions. Then you can do your revision and also the test series, right? Your exam tests, because I always insist that tests should be taken once you are prepared. If you start writing the tests without preparation, you will get a kind of a demoralizing, this thing. But now you have enough of knowledge, I think sufficient knowledge, I should say, and you are well prepared to and geared up to write the test, right? So all aspects of the syllabus have been covered mostly, and whatever is left will be covered in a couple of sessions. Nothing will be left out. Only thing is you have to build up your own self-confidence, cool mind. Okay, we'll have a small session towards the end of today's discussion. Let's see today's topic. Very, very important this year. I'll tell you why. Amendment and basic structure. Emergency provisions, of course, they are important, but for this year exam, why these two are important? Can you just, try to recollect?
Supreme Court, that 103rd Amendment is also.
Yes, no, that is what is going on. Amendments are challenged, they are upheld, or they are declared as constitutional or unconstitutional on the test of basic structure, because basic structure is not defined anywhere, right? Even the Keshwanan Bharti case, where this doctrine of basic structure was established, even in that case judgment also the judges have not defined, and thereafter also it's evolving from case to case basis. But I'll give you certain principles based on which this doctrine can be established, more or less established, but not completely. We cannot define what basic structure is. We can come very close to a definition as such, but no proper definition, because it's not defined either in the constitution itself or in the judgment which brought about this doctrine. But my question is different. Why it is important from this year's exam point of view? Basic structure. Just guess. Yeah. Exactly. This is the answer. In fact, there is one more factor. But most important factor is, in 1973, Keshwanan Bharti judgment was there. It came in 1974, of course, but 73 case we say. And this year is the 50th. Second, the petitioner in the Keshwanan Bharti case died this year. So both these factors, see, you have to be very chalak, very careful. And you keep on watching what is happening, connect them. And this is what the examiner is also looking into. Right? So this year it's very important. That's why I took up this topic, that I'll myself guide you on this. It's not that I'm an authority, but yes, I thought I can address your anxieties on this or your queries on both amendment and basic structure, linking it with certain other features, important features of the Constitution. Before we start the slides, let's have a very brief discussion of about 20 minutes or half an hour. What is amendment, first thing? To amend, to bring about any change, modification. So that means when we are talking about Constitution, it is the amendment, change in the Constitution, modification in the Constitution. Simple meaning. Why do we need amendment? What is the reason? Why? Why amendment is required in Constitution?
Sir, if I may,
Yeah.
changing nature of society and living constitution बोलते हैं.
Exactly, you gave the right nomenclature. Our Constitution is a living document. It's not an inert document. This concept of living document has been taken from USA. But US Constitution has not undergone so many changes or so many amendments as our Constitution has. Does that mean that our Constitution, though we picked up the concept from USA, but our Constitution is more amenable to amendments? Or in the last, about 75 years of our independence and 73 years of our Constitution coming into being, coming into force, can we say that our Constitution is more living than other constitutions in the world? Though it is the lengthiest Constitution. Yes, we are keeping pace with the changing needs and aspirations of the people. And who has given the Constitution to us? The people. The people have given themselves the Constitution. People express their, aspirations, their desires for any changes to keep pace with the changes in the society. And that is why amendment is required. Now, we'll discuss about there is a specific provision for amendment in the Constitution. And that specific provision is Article 368. The question is, what is written in Article 368? How does the Parliament, mind you, the state legislatures cannot amend the Constitution because they do not have constituent power, they have only legislative power. They can make laws, but they cannot either amend the Constitution or bring about any changes in the Constitution. Right? So, the power and procedure, both, if you look at, open your Constitution 368, it says power to amend the Constitution and the procedure to be followed. Now, when it comes to giving power to the Parliament, is it unlimited power? Whenever we talk about power, authority, it cannot be absolute authority. It cannot be, unending, open-ended kind of a exercise of power. Where it is written? Is it written in the Constitution that there will be any, speed breakers, barriers, Lakshman Rekha? To what extent? Constitution doesn't say that. 368 doesn't talk about that. It says power to amend the Constitution. Now, the question comes is, to what extent? Since it is not provided in the Constitution, and the logic says that it cannot be unending power. It cannot destroy the Constitution. Can the Parliament, amendment does not mean destruction. Who gave us the Constitution? Who drafted, who gave us, who enacted? The Constituent Assembly. Constituent Assembly had one major task, that was to give us the Constitution. And they created that. Can you destroy your own creation? After that, you know what happened to the Constituent Assembly? Once the Constitution came into force on 26 January 1950, it was adopted on 26 November 1949, enacted and adopted, as you can see from the preamble. After that, what was the role of the Constituent Assembly? Their task was over on 26 January 1950. What was the role? When was the first general election held? 1952. Yes. So there was a gap between 26 January 1950 to 52 when the first parliament was constituted by way of election, general elections. So the Constituent Assembly had to work till that time as the parliament. These are the facts you should know. You never know, a question may be asked on these issues also. So whenever you study any topic, please get into the depth of everything. Analyze that in your mind, refer to the information available, so that your knowledge base is very strong. Now, so from where we got this basic structured doctrine? This is where, see, whenever there is a gap, what is the role of judiciary? Judiciary is there to interpret law. And Constitution is our fundamental law of the land, supreme law of the land. So it becomes, under the process of judicial review, it becomes the constitutional obligation on judiciary to interpret not only the provisions of the Constitution, but also the laws, the amendments, or even, executive actions, legislative actions, whether they are in conformity with the provisions of the Constitution or not. Can you tell me a term? Just now I said, everything has to go as per the provisions of the Constitution. What is that term called? What is that term called?
Sir, rule of law.
Rule of law talks about law. Law is supreme. Nobody is above law.
Could you repeat the question?
Yes. Every act of all the organs of governance should be in accordance with the provisions of the Constitution.
Validity,
Constitution
constitutional
is a
validity.
supreme power.
Supreme power, no. You said something? You're talking about procedure only. I'm saying
Constitutional
governance. Tomorrow you are going to become IAS officers. You are going to govern. You are going to implement laws. You are going to be part of executive. Your action should be as per the provision of the Constitution. Otherwise it will be, if it is ultra virus, even an executive action, not only the law, not only the amendment. What is that term called?
Constitutional validity of
No, there's a term called, it's called,
Federalism.
pardon?
Federalism.
No, federalism is something different. Federalism is only one aspect of our governance. Anyway, It's called constitutionalism. It's a political philosophy. When we add anything, ISM, it becomes a philosophy. Constitutionalism. And, for law students who are studying law with me, they must be knowing the first topic in Law Optional Paper 1 is constitutionalism, constitutional conventions, and salient features of the Constitution. So, constitutionalism is a political philosophy according to which every action of any organ, under the concept of separation of powers, we have legislature, we have executive, we have judiciary. 3 organs. Legislature has the duty of making laws. Executive implements them. And the judiciary interprets them. Now, all 3 organs have to work under the total umbrella of Constitution. Nobody can go outside that. No law, no amendment. Because why I am telling you, this basic structure has got a very strong link with constitutionalism. Right? So, when we say no organ of the governance can function, should function, they should function as per the provisions of the Constitution. Nothing outside that. If it is outside, the judiciary should throw it out. Right? So then, Constitution also has certain important features. Important features means without which the Constitution or our system of governance will become meaningless. To start with, we go back to our preamble, because preamble reflects the soul. It's it's a mirror image of the entire Constitution. It gives us the gist of the entire Constitution. And Constitution means to constitute a law which constitutes a nation, a state. And the 4 elements of state are, can anybody just quickly repeat that, or I'll explain, no problem.
A government, people, and territory, and okay, 4th one is
Sir, you people are making a very, I should say, very silly mistake. You are trying to mug up the things.
no, sir, I'm not trying to mug up.
No. That's why you are struggling with कौन सा है, एक भूल गया, कौन से हैं, नहीं, not that kind. Just create something in your mind. If you find a vacant island somewhere, you want to go and settle down there, make a state over there. So what you need, first thing you need is the territory, isn't it? A defined territory. Then the people who are going to population. And third, the population has to be governed. You need a system of governance. And above all, you need sovereignty. You must be completely independent. You must have internal as well as external sovereignty.
Sovereign state.
So that's what sovereignty is. You are not being dictated by others. You are free to make your own. You are free to take your own decisions. Free to make your own laws. Unlike the British India, when laws were made by the British Parliament for us. So we were not sovereign. We are sovereign now. So these are the 4 elements of a state. Now these 4 elements, when we talk about these 4 elements, the important element is the governance. And this is where the Constitution comes into play. Constitution tells us what kind of state we want to constitute. So we, the people of India, constitute ourselves into a democratic, sovereign, republic, socialist, secular have been added now. But earlier there were three things, three elements. Sovereign, democratic, republic. That means they are the three essentials, without which our nation, the system of governance, the nation we wanted to constitute becomes meaningless. That means democracy becomes the first basic structure, fundamental structure. Sovereign state is a fundamental structure. Nobody should come and dictate us. Republic, head of the state is elected, is the basic structure. Secularism, added by 42nd Amendment, but yes, it was already there, Article 25, 26 and others. It was not brought about from outside. It was already there in the Constitution, but made, highlighted in preamble. So secularism is a basic structure, fundamental. Socialism, socialist economy is basic structure. This is how the state is constituted. India is constituted. Union of state, Article 1, Bharat, India, that is Bharat is union of state. That means it is, of course, federal. You said federalism is only one basic feature of the Constitution. That is also coming in. Independence of judiciary. Recently, a debate is going on about collegium system, isn't it? NJAC, how it was termed as unconstitutional on what basis? Supreme
Sir,
Court
independence
said,
of judiciary was questioned.
independence of judiciary, that means independence of judiciary is also one of the basic structures. This is what has been interpreted in the judgment. Now, think of these. So this basic structure doctrine has evolved over a period of time and still being evolved through various cases, through various interpretations. Right? So some basic things I am just trying to make clear to you. So these, when we start with this basic knowledge, it will be easy to understand the entire session today. First thing is power. Power to what extent? What parts of the Constitution can be amended and what not, if at all? These are the questions which we have to answer, and please be very, very attentive today because it's very important topic. Second part is, of course, the emergency provisions. What has brought about, I mean, we say we are a federal structure. But when any kind of emergency is imposed, whether it is national emergency under 352 or a state emergency under 356 or financial emergency under 360, what change it brings about in the system of governance? This should be, these are the questions which should bother you and which are asked in this examination. It's not a clerical examination or a bank probationary officer examination. Here you have to be very, very analytical. Merely reading provisions of the Constitution which deal with the emergency, three kinds of emergency, is not going to serve the purpose. Then you are just mugging up. But to make your understanding strong, you must know what brings, any emergency causes what? How it disturbs the normal functioning governance of the country. Ours is a federal structure of governance, isn't it? Federal means what? What do you understand by a federation? How the federation comes into existence, into being?
The
Yes.
sharing of power between center and state.
That is one of the features of
they
federalism.
come into existence through either an agreement agreement between states that will form a federation, huh? Or
Yeah.
either they come into existence.
A kind of a treaty
Agreement is the word.
agreement. Yeah.
Agreement. You know what happens? There are units which can be called as provinces, which can be called as independent states. When we say a state is independent, that means it's a sovereign state, it has got sovereign powers, absolute independence. But when they decide to come together, form a federation with a federal government, which we, in our India's this thing we call it central government. How the states join, form federation, that is, in real federation, it is the result of an agreement, which is there in USA example. So, by way of agreement, what the state does, they surrender certain sovereignty to the federal government and keep something with them. That is where the separation of power comes, the separation of powers between state and center. Right? So now, when we say it is the result of an agreement, second is, if the state wants to get away from that federation, they have the choice.
Right to cede.
That have the right to cede, yeah. But what about Indian Federation? Does Indian Federation, federalism, has these two features?
No.
No. India became a federal state not by virtue of an agreement. The states decided to merge into a union. And when they merge into a union, they lose the second power also to cede from the federation. They cannot.
Sir, I have a question, sir.
Yeah, please.
Sir, so you say there's no agreement. We had signed instrument of accession and all. So isn't that kind of an agreement? Aren't we putting princely state under our
Yes.
control?
Yes, very right. See, under the Indian Independence Act, 1947, two dominions were created, India and Pakistan. In the British India, we had provinces and princely states. As far as provinces were concerned, there was no question of any, annexation or accession or whatever. They automatically became part of the India Dominion or Pakistan Dominion. Question was about the princely states. They were, the letter of accession you cannot equate it with agreement. Agreement is from both the sides, that okay, these are the terms of the agreement. This much sovereignty I surrender, this much sovereignty you keep. There will be dual citizenship. You keep your citizenship also and as federal citizenship also. But there was no such thing. Here it was just either we go to India or we go to Pakistan. That's all. Letter of accession did not have any terms and conditions. Without terms, you have to either merge with India or go to Pakistan. This was not an agreement, please. In agreement, there are terms. There were no terms in this, either
No,
this
so
way
sir,
or that.
It cannot be an agreement because, sir, agreement may at least both party after the agreement exist. यहाँ पे the princely state don't exist only, no. So that is why.
Yes, in agreement, both the parties, that's what I said. I surrender some part of sovereignty, but I keep this. When we talk about dual citizenship, that means if you are a citizen of, let's say, Washington, D.C., if it is a state, I don't know, or Pennsylvania or California, you can also have a citizenship of USA. But no such thing in Indian Union. We have single citizenship. We are citizen of India, that's all. States are gone, that they have lost their identity. Whether it was Junagadh or Hyderabad, now they are all part of India. There is no question of getting away from Indian Union. That is the difference between Indian, but still, which feature of the Constitution talks about or reflects the federal characteristic of the Constitution?
Seventh schedule.
Seventh schedule. The three lists.
246.
Three lists mentioned in 7th Constitution. Number 1, Union list, state list, concurrent list. Union list where the central government has the power to make laws, state subjects on state list, and where both can make laws is the concurrent list. But there is a item number 97 in list 1. What is that?
Sir, I think that is residuary.
Residuary, you think very rightly. It's residuary. That means whatever subjects are not covered in in any of these three lists, the center will have the power. Don't you think it's a unitary feature?
So there's an article अलग से उसके लिए residuary part.
Article भी है, but I'm not teaching you federalism today. I'm just touching upon certain important factors. But I am also telling you that this unitary feature, strong unitary features, which make Indian Constitution or Indian state as a quasi-federal, not federal, truly federal. Neither unitary nor federal. It's somewhere in between. It has features of both. That's what I am telling you. I am bringing you to this emergency provisions. Because during emergency, the states will lose power to make law. And particularly 356. If a state is brought under center's rule, president's rule, and the rule is carried out by the governor, now it is directly under the parliament. Laws for that state will be made by the parliament. Don't you think it's bringing a unitary characteristic into a federal structure?
Yes.
This is what I wanted to. This is what I wanted to bring you to. Yes, please.
But under special circumstances, it changes its characteristics.
Please, my dear friend, we are talking of this.
Emergency, yeah.
ये मैं शुरू में आपको क्या बोला था कि what change this brings about in the system of governance, if you remember. This is the system. It brings about, from federal characteristic, it brings about unitary characteristic. It brings the state, the center becomes all the more powerful. Correct? This is how you have to start thinking for this examination. Right? So we will study today first the amendment, power to amend, procedure to amend, and then, yes, I just talked about power to amend, but what about procedure? Why 368 provides for special procedure? This is again a question which can be asked in the prelims also. Why? Why
because
special provision? You see, you are legislature. Parliament is also a legislature. You have lawmaking powers. How the law is made? Bill is introduced, passed by a simple majority. It goes to the other house, again passed by a simple majority, even one vote, and goes to president for his assent, becomes law. But why amendment 368 provides for special procedure?
Parliament is not supreme, Constitution is supreme. And
that is, yes, tell me.
Because in British Parliament, every law is like an amendment, is like an introduction to this thing, because Parliament is supreme. Yahan par Parliament is not
my question is very simple and straight. When we talk about legislative power is the law-making power of the legislature, isn't it? Do you agree with me?
Constituent power.
No, I'll come to that. I'll bring you slowly to that. legislative power is the simple law-making power of the legislature, both parliament as well as the state legislature. Do you agree with me on this?
Yes.
Yes, sir.
Right. That is the, and those laws are made by way of a majority because there is no special provision given for making those laws. Do you agree with me on this?
Yes, sir.
Yes.
Refer to Article 13. Article 13 says pre-constitutional law, post-constitutional law, and 13.3 talks about what is covered under the definition of law other than the law made by the legislature. These are rules, regulations, ordinances. Who makes the ordinance? Who promulgates the ordinance? The president or the governor? They are also law. Rules are not made by the parliament or the legislature. Rules are made by the delegated authority, that is the executive. But they are also termed as law. Regulations, notifications, or even customs. Even customs. They are not passed by the legislature, but they are also covered. But refer to Article 13, Clause 4. It says what? Law does not cover amendment under Article 368. That means the amendment under Article 368 is not a law as covered under Article 13. Do you agree with me? Open your book and you can see that. And that was added by 24th Amendment. There's a history behind that. I'll discuss that also. Do you agree with that?
Yes, sir.
That means
Amendment is not law.
amendment is not law. Then what is amendment? If it is not law, that means it is a special provision which is there in 368. That means you can make law or you can repeal a law by a simple majority, as happened in the case of farm laws. They came into existence and they were repealed also. But what about an amendment? So they said, Constitution is supreme, you are very right. Constitution is very sacred. Constitution should not be amended so easily as you can make a law. So that is in exercise of its constituent power, not legislative power. Legislative power deals with making of ordinary laws. Constituent power deals with amendment to the Constitution. 368 also says in exercise of your constituent power. It doesn't talk about legislative power. And then Constitution, the amendment to the Constitution should not be that easy, should not be that simple as making an ordinary law, and that is why special provision. This is what should be understood by you. Correct?
Yes, sir.
Right. Now I think we are in a position to start the session.
And also, sir, I'll have one point to put here.
Please, any number of points.
Because constituent power is so important, and so you need involvement of a wider society. That's why you have extra people that have to agree.
No. It is just to make the process little complicated and involvement of or consensus of more number of people. If you say even in 368, there are two special provisions, special, procedures, two special procedures. One is, first, majority of the house and 2/3 of the members present and voting. This is number one. Number two is this plus ratification by more than half of the states. Why this is made so complicated? Why states are also involved? See, once by special provision, you have got the clearance from Lok Sabha, you have got the clearance from Rajya Sabha. Rajya Sabha is the representation from the states, but you still need ratification by more than half of the states. That is keeping in,
Check.
not only check, keeping into view the federalism, concept of federalism. When you want to change any kind of power structure between the state and the center, states must give their ratification. They must ratify, the majority of the states. That is the reason why we need tougher and more complicated procedures in exercise of constituent power. Got it?
Yes.
चलो अब शुरू करते हैं. हाँ, yeah.
Sir, and I remember you said living constitution, though we derive from US, they don't have, because they have originalism more, like they have originalism more. They follow constitution to the T.
Huh.
Yeah, that is what
Yeah. Yeah, you wanted to ask me something?
Yes, sir. My question was regarding the separation of power. Sir, the independence of judiciary
Yeah.
isn't would be correct if we say that the separate independent judiciary is rather the one of the subcategory or the subtopic of separation of power in the basic structure doctrine.
See, if you see the system, there are three, I told you, three pillars of governance: legislature, executive, and judiciary. Are their powers, are they totally independent? Or one wing cannot exercise the power of the other? Is it so? Is there watertight compartments? No. You see, the ordinance making power of president or the governor, he is performing the job of legislature.
Yes.
Some judicial functions also. He is performing pardoning power, appointment of judges, etc. But when it comes to, the concept of independence of judiciary, the interpretation is like that if let's take the case of, appointment of judges itself. If NJAC, what was the structure? NJAC had law minister and 2 expert members which were to be appointed by the executive. 3 members having a good say. If one judge comes to their side, they will decide who will be appointed as the judge. So they said, no, don't have this kind of, yes, there is a procedure that if collegium recommends a name, let it go to the executive for examining, processing, and then go to president for. And if they send it back for reconsideration, then again the collegium sends the same name, they will have to accept it. Now, this is the position. But they say, if a member of the judiciary or a judge in the higher judiciary, High Court or Supreme Court, is appointed only by the executive. Now, executive have no in-depth knowledge of how judiciary functions. Judges write their judgment. How the judges are to be selected for higher posts, for elevation to Supreme Court. Through the quality of their work. Who can understand that? See, I am not an advocate of collegium system or against this system or that system, but I am just trying to tell you the logic behind that, what the Supreme Court has interpreted. Why they say judges appoint themselves? Now, yes, they appoint themselves because they know it's a separate, under the concept of separation of powers, their role is different. If somebody is appointed by the executive without knowing the merits of that person or the quality of the judgments he is writing or his professional expertise, he will create havoc. If an incompetent judge from High Court is appointed to Supreme Court, to the Apex Court, what will be the result? It will be compromising on the quality of the judiciary. That's why they want to have an independence of judiciary. Though it's not clearly written in that's what I'm saying. It's part of basic structure. They have interpreted it like that and very rightly interpreted. You cannot have it since it is not written. Yes, it says the judiciary should be independent. That's one of the major features of any constitution. Now coming back to constitutionalism, one more factor I want to tell you. Sometimes the question is asked, do you agree that merely existence of constitution does not ensure constitutionalism.
Yes.
See, it can be a dictatorship
Yes.
where constitution is there. Constitution is there for every state. How the state is constituted, how it will be governed, for what objectives. But constitution is there, state is there, but they don't go by, it is not governed according to the provisions of the constitution. It is governed by the rule of man, the dictator. So, there is no constitutionalism. There is constitution, but it does not, mere existence of constitution does not ensure there will be constitutionalism also. Chaliye. Okay, now let's start. So it is a process of making changes. We can move a little faster. I think if you have understood the
Yes, sir. Yes,
concept.
sir.
Yes,
Yes,
sir.
Yeah. So power of parliament to amend and the procedure is laid down in Article 368. Very simple. Procedure ensures sanctity of the constitution and keeps a check on arbitrary power of the Parliament of India. इसको थोड़ा सा समझेंगे. When we talk of constitutionalism, it leads to checks and balances and concept of limited governance. You must have heard these terms. Right? That means the governance is limited to strictly to the provisions of the constitution. Governance cannot be. So governance is limited. There is a Lakshman Rekha. And that Lakshman Rekha is the constitution. So sanctity of the constitution and check on arbitrary power of the parliament. What is arbitrary power? What is arbitrary? Means as
contravention
we
with
please.
Article 14.
As we please.
Yeah.
As we please, मन मर्जी, पार्लियामेंट की जो मर्जी वो लॉ बना दे, जो मर्जी वो कॉन्स्टिट्यूशन के साथ खेल ले. To the extent that, okay, we don't want this constitution, we will bring a new constitution. So that has to be checked. Arbitrary power. Power is there. Power of parliament is there. But it should not be arbitrary power. Then this is leading us to basic structure doctrine. Then if it is not arbitrary, then who will check this? To what extent this power can be exercised? चलिए, borrowed from South African Constitution, ये आपका introductory हो गया. So why do we need amendment? ठीक है, आप पढ़ लीजिएगा इसको. If you have any question, you can ask me.
No, sir. No, sir.
Right? These are all terms. I mean, आप तो सिर्फ बस अब notes पढ़ लेना. इसको slide को पढ़ लो, notes को पढ़ लो. That's all. You can stop me immediately if you have any doubt. Right? Sometimes these are framed as questions in prelims. Okay? Then procedure. Amendment by simple majority. It is not very simple, but simple majority is only for making ordinary law. There should not be here amendment. No.
Sir,
Yeah.
if in the exam the word alter is used in place of amendment,
They will not use. They will not use. Alter is also change, but alter word does not occur anywhere in the constitution. It's only the amendment. So they will not ask you that question, which is not there in the statute. Okay?
Sir.
Yeah.
Sorry to intrude.
No,
Sir,
any number of times.
amendment of by simple majority is also an amendment, no? Like, but then it's limited to certain, like for example, Article 4 types, like where you can maybe article where you can
See, those are special provisions provided in the constitution itself. When we say the territory of the state to be changed, we are talking about Article 4,
area.
right? Changing the area. and creation of new states, altering the boundaries, etc. There is a special provision, that is simple majority. There is a special provision given in the constitution itself. But that is not amendment. That's not amendment. Amendment is when you amend the first schedule, where the name is changed, like what happened in J&K. State turned into 2 UTs. It necessitated an amendment to the, but that amendment of course is by a simple majority, not by this.
Yeah.
Right? Okay. Amendments contemplated in 4, 169 fall within this category, right? They are specifically excluded from the preview. ये है, इसको याद रखो. When we are talking about the larger power of the amendment, which is enshrined in Article 368, we are not talking about these small amendments, which are specifically given in articles concerned. Right. Then, amendment by special majority. Okay, fine. Then, special majority plus ratification. I gave you the reason also. Right? Because wherever the question of federalism, the change in structure of power, separation of power comes, states have to ratify.
Sir, then what is effective majority?
Effective is present and voting and then total majority of the house,
Okay.
which can bring about the necessary change or, make that a law or pass it, treat it as passed. That is effective. Okay? Which brings about the desired effect. Right? Now, these are, you can just go through them. रटना नहीं है भाई लोगों, ये समझ लो पहले. अगर आप इस तरह से, if you start thinking like this, understanding the basics, there won't be any need for mugging up. Right? Go with the flow. Right? चलिए. Now these are the steps. बड़ा simple है. कैसे होगा, एक हाउस में होगा, दूसरे हाउस में होगा. Now these are rules of procedure. See, what 368 does is two parts. One is power to amend, other is procedure. It lays down a major procedure, major two procedures. The nitty-gritties of procedures will be there in the rules, which are framed by the Parliament, concerned house.
Sir,
Yeah.
a question is that can I, as a legislature, can I maybe amend 368 itself?
Very good question. Very
And I'll
good
be like, I
question.
don't need so many majority.
Very right. See, when we say in Keshwanand Bharti also, the judiciary said 368 gives complete power to the Parliament to amend any part of the Constitution, but subject to basic structure. Amending the Constitution or exercise of constituent power is itself a basic structure. So can you amend the basic structure, 368, constituent power of the Parliament? As we said, independence of judiciary is basic structure.
Procedural structure.
Exercise of constituent power is also basic structure.
So I'm not taking away the constituent power, but then the procedure, itna elaborate procedure, maybe I'll say ki, oh no, only Parliament majority has to say, nothing more than that. This is too much.
See, my dear friend, if such a situation comes, it will again go for judicial scrutiny. and they will decide whether they have exceeded the Lakshman Rekha of basic structure or not. It will be tested on the touchstone of basic structure. Right? Chali. Then, position of Constituent Assembly, I have already told you. This is sometimes a question of subjective discussion, which I don't think we need to discuss right now, because this is not relevant to your prelims. Maybe for mains we can, once you clear the prelims. So what is the difference between the legislative power and the constituent power? You can just go through it. I have explained everything. If you have any question, please ask me. Right? Just go through that in 1 minute, less than a minute rather, and then if you have any doubt, please do ask me. Otherwise, we'll proceed.
So you can proceed.
Yeah, thank you. Again, basic thing is this: exercise of which makes laws, and constituent power is the power in exercise of which the constitution itself is made, unmade or altered. Right? Alter word we have used, it is not used in the constitution. That's why our friend asked me that. Okay? Right. Now, power to amend. This is where we are leading towards the basic structure doctrine. Unlimited power to amend the constitution is subject to only one. A question will be framed on this. I tell you, my intuition is saying like that. इसको किसी तरीके से वो घुमा फिरा के जरूर पूछेंगे इस साल, this question, or something related to basic structure, right? Should not be, yes. ये है the limitation put on that, power to amend. Concept of constitutional identity. This is the term we are introducing. What is this constitutional identity? I have my own identity, he has his own identity, you have your own identities. I am known by my name, my features, everything. If I change my name, if I change any bodily feature, I'll be losing, maybe my face gets disfigured. People are not able to identify me. I have maintained my identity through my not only outlook but my behavior, my principles, my ideals. And those are the ideals which identify me and which distinguish me from others. Not only the looks, sometimes the looks may be deceptive, you may get confused. But what are my features, my nature? If I am teaching you today, how it is different from other teachers? There are thousands and thousands of teachers who are teaching Constitution. But what makes me different from others? This is my way of teaching. And if I change that way, it will be amending and affecting my identity. My identity might get confused with somebody else. And this is where, when we say constitutionalism, provisions of the Constitution and the ideals which make it a different identity. And this identity should not be changed. Neither the physical outlook, but more importantly, the principles enshrined in that. And those are the principles which we term as basic structure, which the judiciary says form part of the basic structure. So if you change the basic structure, it will change constitutional identity, isn't it? Identity of the Constitution itself. Take away secularism, make it a theocratic state. What will happen? The whole
Identity is
state.
lost.
Yes, identity will be lost, a new identity will get created. Change from democratic form to some other form. Dictatorship or monarchy or something. Identity will change. So that is why the concept of constitutional identity leads us to basic structure.
Sir, I just wanted to ask you about if this is right. The statement that I'm going to make about constituent power and legislative power. So, constituent power may probably you can circumvent part 3. But then legislative power may you cannot circumvent part 3. No, all laws cannot is that
No. I'll take you, we are coming to your, I'll answer your question when we talk about Gorakhnath case and Sajjan Singh and Shankari Prasad case and then leading to Keshwanand Bharti. Just for few minutes, hold it, okay? You are talking about part 3. You know, okay, let me tell you now itself, then it will become easy at that time. In Sajjan Singh and Shankari Prasad, Supreme Court held that you can amend any. The amending power means any part of the Constitution. Gorakhnath said no, you can't amend part 3. You can amend any other part. Power. That was the interpretation of the same Supreme Court. But this was then to bring about the change. I mean the restriction Gorakhnath had put that you can't amend part 3. 24th Amendment was brought about. Then came Keshwanand Bharti case. And Keshwanand Bharti said no. Upholding the constitutional validity of 24th Amendment, the Supreme Court said you can amend any part of the Constitution, including part 3. But basic structure. Restrict yourself. If you are amending any fundamental right, do that. And you know, post that Keshwanand Bharti case, one of the fundamental rights was taken away and made a legal right.
property?
Right to property. So part 3 was also amended. Isn't it? And then its constitutional validity was upheld in Minerva Mills case in 1980. They said, yes, it's quite constitutional. Let's come to that, okay? Now,
Okay,
yeah.
sir, thank you.
Welcome. Now, it's based on the principle that a change in a thing does not involve its destruction. ये important point है. You should not destroy a structure created by you by just exercising your constituent power. So, yeah, आ ही गया वो. Right? Overruled means they said no. 368 doesn't include, it says no, it includes 368. That 368 is also law, amendment is also law. Then came 24th Constitutional Amendment. 13.4 was inserted. And Keshwanand Bharti. Just remember this chart, that's all. Very, very simple. For prelims, you don't have to remember many cases. But these are, at least these 2 cases, you must remember in this 24th Amendment. ठीक? Now, overruled Gorakhnath's case. Now, in this case also, certain basic features, basic fundamental structure was indicated. I'll say indicated, not not laid down. Supremacy of the Constitution, republican and democratic form of government, secular, separation of powers, federal character of Constitution. Right? So, some features. Later on we will see S.R. Bommai's case, secularism came, in Indira Gandhi Rajnarayan case, judicial review came, all those things we will see, yeah? But you need not remember all these judgments, please. Only very, very landmark judgments. See, why this 13.3
So 13.3 defines law.
defines law, but why it appears here?
What is it? Constitutional amendment acts are not law. Because sir, 24th amendment they said no ki
It came
article
after that. 13.4 was inserted after that.
13.4, yeah.
Yes,
13.4,
okay.
Ki this is constitutional
Sure.
amendment are not law.
Yeah. Judiciary established. Now there is criticism also. What can be the major criticism in your view?
Subjectivity. Written okay bhi, you are letting it subjective.
This is one aspect. Other.
Clearly mentioned what all parts come under basic structure.
You know what critics say? That our constitution provides for, let's say, independent legislature, independent judiciary. I'm not talking about executive. Okay. Legislature is amending in exercise of its power given under the Constitution, 368. Judiciary has judicial review, but can they throw that amendment into waste paper basket because they are testing it on a touchstone which is not well defined? It's their subjective.
Yes.
Yes, this is the major criticism, and it's going on. I'm telling you, in judicial legal profession.
Judicial activism.
Yes, this discussion is going on. Judicial activism is only one part of that. Judicial activism is a very, very general term. When we say any act, any
Judicial overreach.
overreach is also something more than that. Activism se upar hai overreach. But then they say, how you will control it? How you will control judicial activism and judicial overreach? What is the factor which controls that?
Appointment, sir. Appointment.
No, sir, no. Judicial restraint.
Restraint, correct.
Yes, judges themselves, they put certain Lakshman Rekha.
Self-regulation.
Kaise? Judiciary has no role in making laws, but it can guide that a law is needed. It cannot enact laws. Take the case of
Same-sex marriage.
Vishakha case, sir. This is still going on. Debate is a thing which has already been decided. Vishakha case.
Guidelines.
They only issued guidelines. They said no. On this issue, sexual harassment, we cannot make law. We can only provide guidelines. Law will be made by the parliament, legislature. And law was made, POSH Act 2013. So there is a Lakshman Rekha which the judiciary itself is drawing, and that is called judicial restraint. Within that, they will have to work. Yeah.
But as a social view or a layman view, don't you think so that people's expectations are likely more inclined towards the judiciary rather than the legislatures?
Why? I'm telling you why. See what happens. We say we govern ourselves in democracy. Do we govern ourselves directly? No. We govern ourselves through our elected representatives. And it is supposed that these elected representatives should know or find out the expectations of the people, the aspirations of the people, and make laws according to that. We have recent example of farm laws. Without knowing or assessing the real pulse of the people, these laws were made. And again, after huge protests and everything, these were repealed. Now, if judiciary also starts doing like that they interpret in one way and there's protest and they change their interpretation. Do they do that? They don't. That is why people have more confidence in judiciary. rather than on other two wings of the governance.
Sir, but they are not accountable to the public. No, that's why they can do.
Sir, they are accountable only once in 5 years. One, when they go for re-election or for their verdict, people's verdict. Next 5 years, once they are in power, they make laws according to what they feel like. But then there should be some authority to check that. Check and balance, that is what is constitutionalism. And that check and balance is done by the judiciary through a process of judicial review. And that is why people consider judiciary as the something where they can get a fair justice. They have more faith. It's but natural. We have seen the examples before us. When Justice Chandrachud says something, people, applaud that. Yes, there is at least one Chief Justice who is like proactive, little bit proactive or trying. Otherwise, the case is going on, hearing is going on same-sex marriage. Nobody would have looked into that. But he said, no, let us examine this. They may come to a conclusion, I don't know, it's only speculation, matters before the court, we don't know. But at least some debate has generated. Some brainstorming is going on. But when it will come to ultimately lawmaking, if there is a need for a law, they will say, go to parliament. They will make laws. We cannot make laws. We can only say, yes, there is a need for a law. Okay? Now, chaliye. Now, see, when we talk about assembly, means constituent assembly. Those who are criticizing this doctrine, they say, the constituent assembly, the makers of the constitution did not specify or what are essentials and what are non-essentials. When we say essentials will only form basic structure or fundamental structure, they have never defined it. Okay? But then there are arguments in favor. Constitutional identity cannot destroy coherence, durability, derivative power and not unlimited power. ठीक? चलिए. Now we come to 42nd amendment. Some difficulties came because of this Keshavanand Bharti case and the basic structure. You don't need to study it in great detail. Just go through it and then what happened after that in Minerva Mills case. That up to that only. 368(4). Now, what do you understand by this statement? What it is restricting? पढ़िए इसको. What restriction it is bringing about this 368(4) amended as by 42nd amendment?
Sir, it is calling that no court can have judicial review over a constitution.
Judicial review, it is curtailing judicial review. तो ऑटोमेटिकली आपके दिमाग में आ जाना चाहिए कि नहीं, जुडिशियल रिव्यू इज ए बेसिक स्ट्रक्चर. चलिए.
9 sketch.
ठीक. दोनों क्या है? अनलिमिटेड पावर गोइंग अगेंस्ट बेसिक स्ट्रक्चर एंड टेकिंग अवे द जुडिशियल रिव्यू. चलिए आगे देखते हैं. मिनर्वा मिल्स केस, बस इतने केस, 4-5 केस दिमाग में रखना और याद करने की जरूरत है.
368(4) वो तो हटा दिया था ना सर बाद में कहीं.
हाँ, अभी इसमें आ रहा है ना ये.
आएगा ना.
आ रहा है. ठीक.
4:1.
राइट. डन. ओके.
Yes sir, yes.
Yes, sir.
बस समझते जाओ, कुछ भी रटने की ज़रूरत नहीं है यार। जब आप पेपर में आएगा ना सामने, अपने आप याद आ जाएगा, मेरी शक्ल याद कर लेना उस टाइम। वमन राव's केस again same, but one more case I will mention here. Yes. From which date? See, 9th schedule may, if a law is put in the 9th schedule, prior to Keshwanand Bharti, it used to become outside judicial review. It cannot be challenged. It could not be rather challenged in any court. But post Keshwanand Bharti, now even if a law is put in 9th schedule, after 24th April, the day on which this judgment came, it can be challenged. It is subject to judicial review. This is a major change. बस इतना याद रख लेना. Right? चलिए. This is the case. Coelho's case will be open to challenge. बस ये है. This is another aspect which was dealt with in Minerva Mills case. I think not with you people, but in my law optional class I have discussed about this. The relationship between fundamental rights, DPSP and fundamental duties. This is one of the topics in law optional, but you need not get into that. Only thing is, which the tussle has been going on through judicial pronouncements as to which one is supreme, which has supremacy over other. In this case and later on other judgments also, Supreme Court says a balance has to be maintained between the two. DPSPs are the duties cast upon the state, that you will govern as per these principles, as per these directive principles. And fundamental rights are the rights of the people. So a balance has to be maintained between rights and duties. Fundamental duties are of course for citizens, part 4A. Power of judicial review is part of basic structure. Limited amending power. There are 3 more judgments. If they ask you, it should strike to your mind, yes, they are also there. Sometimes they may put the name of the case also. So, Bombay case, judicial review, federal structure, unity and integrity, secularism, socialism, social justice.
So this is SR Bombay, na? Karnataka.
SR Bombay, yes. L. Chandrakumar case is very important, but I will not get into that detail today because it is not required. But power of judicial review you can just remember. Yes.
And sir, उसमें ये भी था ना कि tribunals can now, like High Court have power over.
See, my dear friend, if I start talking about that case and it's
yeah, it will be never ending.
it will take me 1 hour. Okay. But yes, you very rightly said that. See, okay, chal, since you have asked, let me quickly explain to you this L. Chandrakumar case. Under the Administrative Tribunals Act, the administrative tribunals were created and the appellate authority was made Supreme Court. Basically, why administrative tribunals were created under Article 323A and 323B through 42nd Amendment? To lessen the burden on high courts. Right? But what will happen? Of course, keeping in view that idea, they said, okay, if a administrative tribunal has passed any order, it should be appealed only in Supreme Court. Now, Supreme Court said in L. Chandrakumar case, what about Article 226? High courts have been given power of judicial review to issue writs, as 32 Supreme Court can do. 226 High courts. So how can you take away the judicial review power of the high courts?
Yeah.
That is why this case is important. I didn't want to get into that detail, but since you asked me, it's my duty to answer, satisfy you. Yes. Okay, chaliye. Supremacy of the Constitution.
4 judges case.
Yeah. This is important from the point of view of this collegium debate going on. So please do remember this case, right? And this year I am expecting a question on that. Basic structure and this collegium. This is the latest case between LG and... Now we come to emergency provisions. I told you emergency is a situation which is abnormal. Under normal system of governance, what we have is a federal, truly federal structure. Clearly well-defined subjects under each list in 7th schedule and other provisions of the Constitution, how the states will function. But if an abnormal situation arises, this whole system will get disturbed. Why? Under the federal system, defense comes under whom? The federal government, the central
Union
government. Central government, okay? Defense of the whole nation. So if there is a war or an external aggression, should the central government not intervene? They should. It's their duty. Earlier in 1975, when emergency, the national emergency under 352 was imposed, the term was internal disturbance. The term was wide open, subjected to misuse, and this is what had happened. You were not born, I was in college at that time, 75, 77. Now, during that time, the reason given was due to internal disturbances. And how those internal disturbances occurred? Because there was a verdict, Allahabad High Court verdict against Mrs. Indira Gandhi.
Yes.
She was disqualified on the under Representation of People's Act.
6 years ban.
Right? So, what happened? There were large-scale protests throughout the country. And that was termed as internal disturbance. So to curtail that, the protests by almost entire opposition other than Congress, and then emergency was declared, promulgated 352. So after that, in 44th Amendment, when Janata government came into power in 1977, they said no, this internal disturbance is a too general a term. We must have a very specific kind of a disturbance, and that was termed as armed rebellion. So internal disturbance was replaced by armed rebellion to make it very difficult to impose emergency. ठीक? This is the background.
So
अब थोड़ा
one more thing it did was that कि cabinet approval is needed. यहाँ पर prime
हाँ
minister
वो प्रोसीजर की बात है कि only simply the prime minister went and asked the president to sign. That was different. We'll come to that. We have got slides on that. Don't worry. But I just wanted to tell you the background and why there was a need for replacement of internal disturbance by armed rebellion.
armed rebellion.
So,
Yeah.
then again, the word armed rebellion, does it only mean that the sticks and the luts will be counted as the arms?
Use of guns, destructive weapons.
Okay.
That's what is armed rebellion is. Like you can have See, emergency can be for entire nation or for parts of the state also,
Particular area.
particular areas. We have a situation in Chhattisgarh. In next slide. Yes, they are armed rebellion.
Yesterday only.
Yes, yesterday 11 people died.
11 people.
Yeah, 10 cops and 1 driver. They died. Yeah, look at the IED. They have, what is IED?
blast. Explosive.
No
IED.
full name.
Nitrate explosive. रुको sir.
Improvised explosive device. अरे ये छोटी छोटी बातें याद रखनी यार. ये मैं बता रहा हूँ प्रीलिम्स में बड़ा काम आती हैं. I learned this when I was in school and I wrote NDA exam. I cleared NDA written twice. Now, in that exam, they used to ask for expansion of abbreviations and not MCQs. You have to write. There I learned this habit of, anyway. It's just curiosity. A situation which is not a normal situation, proclamation of emergency, failure of constitutional machinery in states. This is very debatable. Okay, then financial emergency. 3 kinds of emergencies. So first is 352. Thrice Chinese aggression, which was lifted in 68. 71 Pakistan aggression.
Bangladesh.
75
Indira Gandhi.
internal disturbances revoked in March 77 when Janata government, just before Janata government came to power.
If pressure is satisfied.
Right? War, external aggression, and now we have the armed rebellion.
Rebellion. Proclamation.
Whole of India or any part of India.
Part of.
Right? So, actual occurrence is not necessary. This is important to know.
Yeah.
It's not that armed rebellion has actually occurred, but if there is a reasonable apprehension,
Chance.
yes, an imminent danger.
सर यहाँ पे क्वेश्चन पूछूंगा.
हाँ जी बिल्कुल.
ये satisfaction वाला पार्ट पे.
हाँ.
वो satisfaction part is debatable. No, is that questionable?
It is.
Is that can be questioned in court?
Yeah, it is debatable because it's a subjective decision, subjective satisfaction. So, to me, it may look different. To you, it may look different. But then we have what? Judicial review.
Yeah. Sir, वो कुछ है ना on it should be on record, like it should be something like that.
See, you have not studied administrative law, so I'm telling you, but you will be very soon learning it once you enter the service. Every administrative decision should be a reasoned decision. That means the reason should be recorded.
Natural justice.
That will eliminate arbitrariness. Once you mention the reason for your decision, you will be able to explain why you exercise your discretion in this manner. And that is why the written orders or reasoned decisions are very much emphasized.
Yeah, reasoned order.
Yeah. Right? This is what Union Cabinet has to decide. Within 1 month, earlier it was 2 months. Resolution of the House of the People, Lok Sabha. Automatically 6 months, but can be continued by resolution of both the houses every 6 months. So 6 months, then no upper limit provided this is followed. This cannot be suspended. Earlier, these could be suspended. All fundamental rights. Which case is that? ADM Jabalpur case versus Shukla, right? Yeah. In that case, they said we can't look into that. This fellow is detained. It was a habeas corpus case to produce the body. The court said no. And this judgment is thoroughly criticized even till date. They say it was the black day in the history, constitutional history. So Article 19 will remain unaffected if the ground of proclamation is only armed rebellion and not war or external aid. Please remember these two. These are very important.
Sir, but एक और एक article है ना जहाँ पे president has to come up with it, like a proclamation, अलग proclamation to be like हाँ 32 is also not there.
किसके लिए?
One more I think 358 है कि जिसमें जैसे कि president अलग proclamation लाना पड़ेगा.
आएगा. Just 2 minutes. 2 minutes. I am just introducing it.
Because it was saying fundamental right, that is why.
नहीं उसमें president has to issue a separate proclamation stating that this particular fundamental right is suspended. It is not automatic. Right? I'll come to that. Don't worry. Another 2 minutes. Okay, this is what has been brought about. It may be restricted to a, this is very important to understand now. War, इतना याद करने की ज़रूरत नहीं है, सिर्फ ये टर्म्स याद रख लो.
Rebellion, internal disturbance, Nagas people movement, CSE threat to security, excluding situation, lesser grant, imminent danger, threatened, made partial occurrence.
Achha, just tell me, the satisfaction of president, is his personal satisfaction?
No, it has to be based on something.
It has to be based on the aid and advice of the Council of Ministers.
Cabinet.
President cannot, work, function without the aid and advice of the Council of Ministers, not cabinet, my dear friend.
Oh,
cabinet is a small part of Council of Ministers. Right? It's the top policy making body in the political executive, but what Constitution says is Council of Ministers. Okay?
Okay, sir.
Cabinet also forms part of Council of Ministers. It's not outside that. Okay? Chaliye. There is no bar on judicial review. Only to examining have been observed or not. See what happens if suppose any decision by the president is taken where his satisfaction is involved, subjective satisfaction. The court will not, even if it is the advice rendered by the Council of Ministers, the court of course can look into the overall situation, but court cannot say the advice is right or wrong. So, but the court will look into the basis on which such advice has been rendered, the material, that will establish whether this advice or this satisfaction is mala fide or not, or based on extraneous or irrelevant grounds. Court will look into only this, not the satisfaction itself, not the advice of the Council of Ministers. Please remember this. Right? This is important, which affects the federal feature. Central Parliament gets power to legislate with respect to matters even on the state list. This affects. Right? ये आपको सिर्फ इस एस्पेक्ट को याद रखना है. What effect the emergency brings about. These are important features. Please remember. 358 आ गया भाई आपका. Article 19 will be suspended only when a proclamation of emergency is declared on the ground and not when emergency is declared on the ground of armed rebellion. Number 1, shall apply to any law which does not contain a recital to the effect that such law is in relation to the proclamation of emergency, to any executive action taken otherwise than under a law containing such recital. So this is about, talks about the law which is related to the proclamation of the emergency, and this is what deals with the executive action taken by the administration based on that law. So automatic suspension, clear, freedoms are gone. 19 talks about freedoms. Right?
Yeah, this is what we were talking about. No? Yeah.
Yes.
Yeah.
So once proclamation is gone, Article 19, freedoms again can be claimed. ठीक? Anything which I think it's very clear?
Clear, sir, clear.
Yeah. Right to remedy after emergency is over. This is important. During the emergency cannot be challenged even after the emergency is over. ठीक?
359, yeah. Territorial operation, suspension.
For the entire country,
Particular.
whole or any part, depends on the presidential order. This is important. 44th
So this
Amendment
is because-
amended 359 that 20 and 21 cannot be suspended.
This is because, sir, during emergency they all went to jail. So they're like, "Arey,
That's what I told you, ADM Jabalpur case, well-known case on habeas corpus. बस ये आर्टिकल्स पढ़ लीजिए एक बार यहीं से. You need not read the whole text of, you don't have time for that. Okay, then ठीक, these are the principles. Now we come to state emergency 356. This is important. Failure of constitutional machinery. What will constitute this? What will amount to this? Does a report from governor is required, essential, mandatory or not? These are the questions which should bother you and me. So it is President on receipt of a report from the governor or otherwise That means even if there is no report from the governor,
He's not bound by the report also.
I can give you one example. In 1991, in Tamil Nadu, DMK government was there, and this LTT problem was at its peak in Sri Lanka. I was there at that time as sub-collector. And DMK government was in fact against deployment of IPKF, Indian Peacekeeping Force in Tamil Nadu, in Sri Lanka. They were fighting against the LTT. That was during the time when Rajiv Gandhi was in. He was assassinated in May, I think 21st May, 1991. Now, what happened? The center at that time was asking the governor of the state to send a report that there is a breakdown of constitutional machinery. They wanted to impose president's rule. They said, since DMK government is supporting LTT or going against the deployment of IPKF, it amounts to breakdown of constitutional machinery. The governor said no. He resigned. Mr. Barnala was the governor, and later on I became his OSD when second time he came to Tamil Nadu as governor in 2006. Now, that means what? Even if there is no report from the governor, the president can satisfied that a situation has arisen. So again here the satisfaction of the president is not his personal satisfaction. It's only on the aid and advice of the Council of Ministers. Now, here is the change which comes about, which disturbs the federal structure, makes it unitary. This one, assume to himself all or any of the functions of the government of the state exercisable by governor or any other person. That's why sometimes we say governor's rule. Because president's rule, but being carried out by governor.
On behalf of the president.
Yes. Under authority of the parliament. So everything comes to parliament, center. Okay? Can be subsequently revoked also. ये आप पढ़ लीजिए 2 months, right? Now, this is important. This also forms part of breakdown of constitutional machinery. अच्छा चलिए अब बताइए अभी, after reading this article, 365, what comes to your mind when somebody will say, what is constitutional machinery? Does this amount to constitutional machinery? State has failed to comply with any directions given by the union.
सर क्योंकि थोड़ा सा यूनियन फीचर्स भी है नो
ये है यूनियन फीचर.
ये यूनियन फीचर
ये है यूनियन फीचर भाई. ये देखिए ना, any direction in exercise of its executive power, they give any direction to the state government does not comply with that. And they say breakdown of constitutional machinery. So much of unitary feature this article carries. Right?
Yes.
चलिए. This is the, explanation of breakdown of constitutional machinery. So there are other articles also which you can just simply go through that, but most important is 365. ठीक, कोई इसमें डिफिकल्टी नहीं है.
सर एक क्वेश्चन है, लास्ट ऐसे लैंडमार्क जजमेंट में आपने उसमें लिखा था कि हाँ, इफ सैटिस्फैक्शन इज बेस्ड ऑन गवर्नर्स रिपोर्ट, तो गवर्नर्स रिपोर्ट इज बट मैंडेटरी नहीं ना कि द प्रेसिडेंट
No,
एक्चुअली
no, that governance report also will go to Council of Ministers. See, President cannot act on his own.
ओके, तो काउंसिल ऑफ मिनिस्टर्स में भी मैंडेटरी नहीं ना कि जो भी गवर्नर का रिपोर्ट है
No,
उसके
नहीं है, बिल्कुल नहीं है, बिल्कुल नहीं है. Governor's report is not the final thing. It's only a matter which is placed before for the discussion or decision making of the Council of Ministers. That's all. This is important on the ground of correctness or adequacy. Adequacy cannot be challenged. Only on these grounds. What? Exercised mala fide. There is a case where the governor, in state of Bihar, I'll come. I think Mr. Bhutta Singh was the governor at that time, and that judgment, the court criticized that order. Right? This is the change brought about by 44th Amendment. Time period change हुआ. Maximum of 3 years. Right? ये इसको थोड़ा सा ध्यान से पढ़ लो. It's only about the time period and how it can be extended and how long. Right? कुछ नहीं, फैक्चुअल है. We come to the third emergency, 360. How this financial emergency is asserted, that there is a financial emergency? What will come to your mind? When we are not
Situation
able
like,
to... Yes, please tell me.
Situation like what recently happened in Sri Lanka can...
That's absolutely right. And what is happening in Pakistan now? They are not, they are on the verge of bankruptcy.
Lack of budget.
No, not only that. The first criteria is that the nation is not able to service its debts. When you are not able to pay back your debts, or even the installments, or even the interest on debt.
Interest payments. Yeah.
Yes, you have borrowed money from maybe external agencies like IMF, World Bank, or other countries. Pakistan has heavily borrowed from China for their infrastructure projects. They are not able to service. They are now going to IMF, International Monetary Fund. Give us some more money to come out of the situation. They have only $4 billion of balance left, the reserves, foreign exchange, and they are asking for $12 billion from IMF just to meet their, and 26% is the inflation rate in Pakistan now. So you have seen the situation in Sri Lanka. So if such a situation comes, where your debts have mounted to that extent that you are not able to even pay your EMIs, I should say. वहाँ situation हो जाए, then of course it is a financial emergency. You are not able to pay the salaries to your employees. Financial situation becomes so difficult, unforeseen, sudden crash in the market, shares go down, कागज रह जाए वैल्यू उनकी, your currency gets devalued to nil or something very close to zero. That is the unforeseen circumstances. Sudden natural calamities may happen where you are not able to manage the situation. with your available finances. These are the unforeseen uncertainties. Credit of India is threatened. So, to save the integrity of the nation, कल को क्या होगा? If you have borrowed from some other country, you are not able to serve your, तो आपने बैंक से कर्जा लिया है, कार के लिए, कार लोन लिया है, तो बैंक वाले आगे क्या करते हैं? If you are not able to pay, they take away your car. So here the question of nation is there. Some nation will come and they will occupy us. They'll lay a claim on our assets. Again, financial directions. कि आप ये करेंगे. It is again disturbing the federal structure. Reduce salaries and allowances. कल को भगवान ना करे ऐसा सिचुएशन है हमारी पेंशन कट हो जाएगी, कहेंगे पेंशन इनको कम दो, हाफ दे दो. All money bills after they are passed by the legislature of the state. Parliament में तो money bill जाएगा, it will go with the sanction of the president. If you study the powers of the president, all money bills. But here even the money bills of the state, financial statement means budget of the state, it requires president's approval. Time period change किया गया. Okay. 44th Amendment. This is only factual, just go through it. And this is the end of today's session. Now, house is open for discussion. Any doubts? Anything about your anxieties about the exam, today's session, or any other thing which is bothering you? But only my request is, please, ratta mat lagaiye. Don't mug up the things. Just understand in simple language.
In that reference, I want to ask, as obviously you have a lot of experience and you have seen a lot of students and like many like officers too. It is almost a month left for us. So some special things or some special points you want to let us follow. ये नहीं करना है और ये do's and don'ts. Some specific do's and don'ts.
I'll give both do's and don'ts.
Yeah.
Let's first say do's.
Okay.
इसको ठंडा रखो दिमाग को, दिल को और दिमाग को नीचे नॉर्मल पे रखो. And the best way to do, though I don't get time, best way to do is spare some time for yoga. Calm mind. ध्यान हटाओ उससे थोड़ा. देखिए, you have 24 hours in a day. If you divide it into 3 parts, 8 hours sleep, good sleep. Now you are left with 8 hours of studies, hard studies, revision, test. 8 hours, कम नहीं होते, काफ़ी हैं. Rest 8 hours for your other things, नहाना, धोना, खाना, like that. And read newspapers. Of course, now it is too late for prelims, but yes, news फिर भी सुनो. थोड़ा टाइम निकालो, न्यूज़ सुनो. Only, the headlines or something. If Vayon is the word is one, you can refer to that channel. It gives you a lot of information about international affairs, your national affairs also. Analytical, things are there. Please spare some time for that.
What is the name, sir?
WION, word is one. This is one channel. Very good channel. Okay. That will help you in your current affairs. Newspaper, पढ़िए. चाहे ज़्यादा टाइम मत लगाइए, just headlines to just refresh your memory and keep yourself, abreast with the latest. Cool mind, 8 hours of hard studies. Hard studies. मतलब क्या? पढ़ना है, रिवीजन. अब तक आपके पास सारे नोट्स हैं, सब चीज़ है. divide that 8 hours into different topics or subjects और equally spread over, ठीक है. और पॉलिटी के ऊपर 18 से 20 क्वेश्चन आते हैं, ठीक है. सो दैट विल गिव यू अबाउट 40 मार्क्स, विच इज़ नॉट अ स्मॉल अमाउंट. 40 मार्क्स तो इस एग्ज़ाम के लिए बहुत ज़्यादा है. सो जो कि मेरा सब्जेक्ट है, सो आई एम टॉकिंग अबाउट दैट. डोंट में आएगा, एक तो प्रेशर मत लो. मैं सब कहते हैं प्रेशर सबको आता है, मैंने भी एग्ज़ाम आपकी तरह दिया था यही. I cleared it in my first attempt. But the only thing is, don't listen to others. This is not the time that you should enter into any discussions or arguments. Self-study का time है ये. So don't discuss with others, even if they are your close friends, your co-students, co-aspirants. इस महीने नहीं, अगला एक महीना पूरा नहीं, up to 28th of May. Just concentrate on yourself and your notes, your study material, tests, whatever is there. And don't mug up. क्या होगा इस टाइम पे, in the last 1 month, if you start mugging up, तो anxiety बढ़ेगी और उस anxiety में there are chances you may forget certain important things. जैसे मैंने पूछा स्टेट में 4 elements. So some of you could give only 1 or 2 or some 3, not all 4, and you were struggling to remember the 4th one. नहीं, it should come naturally to you. So develop that habit. अभी भी है टाइम, 1 महीना बहुत होता है. 30 days, 30 into 8 hours, 240 hours you have got. ठीक है, 240 hours में बड़े आराम से सारा रिवीजन हो जाएगा. दिस इज द, जैसे होता है ना, हैव यू सीन द रेस, जब वो एथलीट करते हैं रेस में, इन द फाइनल लेग दे पुट द एंटायर एनर्जी. सो दिस इज योर फाइनल लेग, पुट योर एंटायर एनर्जी इनटू दैट. करो मरो वाला हिसाब है, पर करो मरो का मतलब ये नहीं कि प्रेशर लेके, नो, नॉट अंडर प्रेशर. जस्ट योगा इज द बेस्ट वे, and just few asana or some concentration, some meditation, उससे क्या है, your nerves will cool down और आपका जो हार्ट बीट है ना वो भी नॉर्मल रहेगा. अभी वो टाइम नहीं है कि आप फिजिकल एक्सरसाइजेज करो या ये करो वो करो. जिम विम सब बंद फॉर 1 month. जस्ट स्पिरिचुअल कामनेस, मेंटल कामनेस, लाइक दैट. रिलैक्स जितना हो सकता है. And that's for that I am giving you 8 hours. और 8 घंटे सोना जरूर है. Don't have sleepless nights. Even if it is your, maybe the last few of you may be having the last attempt. But दिमाग पे नहीं लेना बिल्कुल भी. I had the last attempt, my first and last. So उसी तरह से एक meditation is the best way, yoga is the best way. It will take care of your health also. Don't eat too much, no heavy food. ठीक है, उससे क्या होता है, लिथार्जी आएगी, प्लस यू मे हैव सम बॉडीली प्रॉब्लम्स ऑल्सो. स्टमक अपसेट हो गया, ये हो गया, बाहर तो जाना ही नहीं, बाहर खाना ही नहीं है. वट एवर नाइस फूड यू कैन प्रिपेयर फॉर योर सेल्फ और यू आर गेटिंग फ्रॉम ए गुड किचन, दोज हु आर इन PG, एंड ट्राई टू ईट हाइजीनिक लेस फूड. अगर 4 रोटी की तबीयत है तो 3 खाओ या 2 खाओ, कोई बात नहीं. 1 महीने के बाद है, उसके बाद जितना मर्जी खा लेना. बट स्लीप इज़ ए मस्ट. मैं भी अब आपको जो पढ़ाता हूँ यहाँ पे, नाइट आई रीच माई होम बाई 10 o'clock. ओके, देन 11-12 आई गो टू बेड. डॉट एट 7:30 आई एम अप. 7 से 8 घंटे की स्लीप में जरूर लेता हूँ. सो दैट्स वाई आई एम एबल टू फंक्शन सो मच एट द एज ऑफ 64 नाउ. सो दिस इज द, एंड फॉर दिस पर्टिकुलर मंथ, गुड स्लीप, लेस फूड, लाइट फूड, एंड मेडिटेशन एंड योगा. दिस शुड बी योर टाइम टेबल फॉर 8 hours. और 8 घंटे दबा के पढ़ना है, उसमें तो कोई कॉम्प्रोमाइज़ नहीं है. कोई भी डिवाइड कर लो अकॉर्डिंग टू योर ओन चॉइस. सम पीपल स्टडी एट नाइट, सम स्टडी एट डे टाइम, जो भी अर्ली मॉर्निंग, लेट नाइट, जो भी आपका साइकिल है अकॉर्डिंग टू दैट साइकिल, स्टिक टू दैट, डोंट चेंज योर साइकिल नाउ, दैट विल डिस्टर्ब द होल थिंग. सो any other thing? Because I don't think I'll be able to meet you before. But if you have any doubt, any anxiety, anything, you can always call me in the office, phone pay, voice call, video call also. I am available to all of you. कभी भी मेरे अगले 1 महीने में, any time you want any advice, any guidance, other than geography, history, like those subjects which are very, very conceptual and factual rather. But for this, polity, governance, constitution, this, that, current affairs, you want to discuss anything, provided you have time, and my time also is there at that time particularly. और बताइए, anything else?
No, thank you, sir. Sir, are there only other sessions you are going to take?
I think one more. That's what Rajshekhar sir was telling me. Perhaps
Yes.
one more on polity and governance.
Subtopics?
Topics, I think he will decide. अभी मेरे को बोले तो मैं तो अभी भी करने को तैयार हूँ. But the thing is कि it will be too much for you people. जितना आज हमने सीखा है उतना याद कर लो. I am telling you the importance of basic structure this year. ठीक है, इन चीज़ों पे ये हिंट्स होते हैं और ये अपने आप आते हैं, यू नो, थ्रू एक्सपीरियंस एंड यू नो व्हाट वी लर्न फ्रॉम द ट्रेंड्स. क्योंकि ट्रेंड्स है आपका एनालिटिकल और करंट टॉपिक्स के ऊपर, पर्टिकुलरली विद रिस्पेक्ट टू कॉन्स्टिट्यूशन एंड पॉलिटी. क्या रहा है, कोलिजियम सिस्टम, एनजेसी, जुडिशियल रिव्यू, सुप्रीमेसी, बेसिक स्ट्रक्चर. अब तो केशवरन भारती का भी जैसे 50th वो है, एंड दैट फेलो द पेटिशनर हैड डाइड रिसेंटली. सो ऑल दिस फैक्टर्स टेक अस टुवर्ड्स, दैट्स व्हाई आई टुक दिस टॉपिक टुडे. ये इसके ज़्यादा चांसेस हैं क्वेश्चंस आने के. आई एम नॉट जोशी तो मैं हूँ नहीं एस्ट्रोलॉजर के बता दूँ कि ये क्वेश्चन ये होता तो फिर तो कोई बात ही नहीं थी. बट माई एनालिसिस, माई इंट्यूशन सेज दिस आर इम्पॉर्टेंट टॉपिक्स. Federalism, very important, how it changes, the emergency changes, their unitary features, what makes it quasi-federal. आज हमने काफ़ी डिस्कस किया उसके ऊपर. So friends, any other thing? Otherwise, I'll wind up and say bye to you people with all best wishes. Looking forward to one more session if they have planned. Yes, Mr. Rajshekhar is here. No, you can come here.
I came here if you need any assistance.
No, I need your assistance because I need your assistance. They are asking me, is there any more session where I'll be there?
Yes, guys, just we had a discussion, fundamental rights, directive principles of state policy and fundamental duties. So combining these three in the prelims, there are some conceptual questions, analytical questions. So I think that session will be taken by sir. Apart from that, polity, we have covered every aspect of it. Judiciary, we have covered legislative wing, executive wing, center-state relations. So today, amendment and other emergency provisions are also done, and most important, basic structure is also done. So only thing that is left is fundamental rights, DPSP and duties.
Tomorrow and day after, I am having my sessions in OP Jindal University. We have launched our weekend courses there from tomorrow. So 2 दिन तो मेरा नहीं होगा, Monday or maybe Tuesday, but most probably on Monday I'll be meeting you people with this topic. Again, very important, right? Not many cases. मैं आपको डराऊंगा नहीं cases, बल्कि I'll try to simplify the things for you as far as relationship between fundamental rights, DPSP and fundamental duties is concerned. We'll start with basics, and in just 2 hours time, I think 2 or 2.5 hours, we should be able to complete the topic as we have done today. Thank you very much, friends. All the best.
Thank you, sir.
Thank you, sir.
Bye, sir.
Bye.
Sir, will we doing any PYQ today?
You can go and ask Charu. कोई इशू नहीं. सर से बात कर सकते हैं. सिद्धार्थ, हेलो, आर यू देयर?
PYQ कर सकते हैं कोई?
आज नहीं है. लाइक वी विल हैव PYQ सेशंस अब रेगुलरली. जैसे ये सिलेबस खत्म होता है,
Yes,
तो इवन साइंस में भी हमने रोक रखा था ना. जैसे वी विल डू इट ईयर वाइज, ठीक है, इसलिए रोक रखा है. डन. सो आई होप एवरीथिंग इज क्लियर.
Yes.
So probably Monday, agar if sir is exhausted on Monday because he is taking sessions on Saturday and Sunday both the days, so we will plan it for Tuesday. But Monday we will have a session. If not Polity, then we will have a mentorship session or previous year question session or special session. So we will fill in. ठीक है?
Okay, sir.
Done. Okay. Bye Dhanush. Bye Siddharth. Everyone.
Bye, sir.
Bye.